Tonight, affirmative action is no longer legal at U.S. colleges and universities after a Supreme Court opinion came down this morning. Anthony Montalto spoke with a legal expert to find out what it could mean for college admissions.
The High Court's conservative justices voted to overturn the policy that allowed colleges and universities to use race as a basis for admission. Zip codes and essays could soon mean a lot more in the college admissions process. That according to Mercer law professor David Odell after a major Supreme Court decision Thursday.
It was predictable that this was going to go away in a kind of a formal way, but what's going to happen is probably not all that much.
Odell believes colleges and universities will find another way to stay diverse, but he says many experts expected this outcome.
Everybody knew this was going to happen. And the question is, and all the big colleges and universities, they've already been anticipating this ruling. This is not a surprise to them.
Chief Justice John Roberts wrote in his opinion that the ruling should not be taken to mean colleges cannot consider an applicant's discussion of how race has impacted their life. But Justice Ketanji Brown Jackson wrote she felt, quote, deeming race irrelevant in law does not make it so in life. Odell says this issue isn't new to Central Georgia, where schools once denied applicants based on race.
Tried to do the very best it could to overcome that history. So it's a particularly sensitive issue in the Middle Georgia context.
Now, we reached out to 5 Central Georgia colleges and universities. 4 of them directed us to the state university system. Mercer University did send us a short statement saying they see the value in having a diverse student body, and they believe they'll be able to do that without race-based admissions. In Macon, Anthony Montalto, 13 WMAZ News.
The university system did not reply to our request for comment. The High Court is also expected to hand down a decision on student loan forgiveness in the next several days. They're also slated to rule on whether private businesses can decide not to serve customers based on sexual orientation.